Did Nigerians throw away the baby with the bathwater? Did the judiciary itself instill confidence in the people? It is debatable, especially as 2017 witnessed the prosecution of some serving and dismissed judges and even senior lawyers in the courtrooms. But apparently worried about this issue, the Chief Justice of Nigeria on September 28 announced the setting up of a Corruption and Financial Crime Cases Trial Monitoring Committee, initially to be chaired by a retired Justice of the Court of Appeal, Justice Salami, who opted out for personal reasons. He was replaced by a retired Justice of the Supreme Court, Justice Sulaiman Galadima. The composition of that committee also elicited a lot of reactions, and we have two of the prevailing views in this recap.
I think we have to start by congratulating the Chief Justice of Nigeria for ordering or directing every court system to set up a division to try corruption cases. That is a major achievement on the part of the Chief Justice. It's, what word shall I use? In a sense, it's like going to the moon, you know, in terms of anti-corruption war. It's a great leap forward. So he is to be congratulated. It's a major development.
And that's something that you've advocated in the past.
In fact, we have a bill before the National Assembly which is not moving. So it's a very great achievement. We have to congratulate him. Now, he then went further to set up a monitoring committee that is going to monitor what these judges, these specially selected judges, are going to be doing in their courts, so that reports can be written to the NJC to allow them determine whether those judges are living up to expectation, whether they are meeting all the provisions of the Administration of Criminal Justice Act. Again, brilliant idea. Brilliant idea. It's to be praised for it. Now, the devil is in the details. The detail in this case is including the NBA president and former NBA presidents in the monitoring committee. I think that's where things got wrong. You see, because these people, amongst these people are those currently defending high-profile looting defendants. Amongst them are those who have done it in the past, whose case, the case he was handling, was responsible for the removal of Justice Salami from the presidency of the Court of Appeal. Because the then Chief Justice of Nigeria illegally and immorally and unconstitutionally approached Salami to intervene in a case concerning Sokoto state governorship, which was believed was going to end in the ouster of a favorite government candidate. He refused. And they were so desperate to get this illegality done, that is, intervene in the case, that they attempted to promote him to the Supreme Court so that they can get a compliant person in the Court of Appeal to do it. He refused to be promoted. In fact, kicked upstairs. This is really what they wanted to do. And for that reason, they suspended him. Not only that, that case, which was meant for the Court of Appeal, because at that time, Supreme Court had no jurisdiction over governorship cases. It ended at the Court of Appeal. The Supreme Court now violated the Constitution, took the case upon itself, dismissed the action of the unfavored candidate in order to save the favored candidate. So a major illegality was carried out by the Supreme Court. And as I said, one of the lawyers who is now being asked to be in this committee was a lawyer to that candidate who was favored. And you can't really say he had no hand in what happened. So you can see that the whole thing is a non-starter with people like that. Not only that, some of them are actually currently handling high looters cases in the courts. Others are handled in the past. You know, these things create a state of the mind in which they begin to see these high looters as people who are worthy citizens, worthy to be defended. And not only that, they have even created a profession within the legal profession, specializing in defending high looting cases. They introduce obstructions, frustrations, adjournments, traveling overseas for medical attention. To summarize it, frustrating these cases, some cases have lasted 15 years, and to go up to the Supreme Court and come back. And these are the people who are now supposed to be monitoring whether corruption cases are being handled effectively, efficiently, and speedily. Obviously, their culture is against the very thing they are supposed to monitor, and they will subvert the whole process.
I don't think at the committee level we would dignify such complaints with any consideration. There is no conflict of interest. Whose interest? There are three parties in a criminal matter. Firstly, the state. Secondly, the accused person himself. And thirdly, members of the public. Each has a stake in the outcome of the matter. Now, it's not possible to imagine that people who have specialized in the defense of accused persons for over 30 or 35 years, 40 in some cases, have nothing to offer as to why cases are delayed in court. Indeed, some of the people against whom this malice has been brought about are people who have, while they were occupying positions of responsibility in the legal profession, contributed immensely to the improvements in the criminal justice system. So the mere fact that you defend an accused person doesn't make you an accomplice to the offense allegedly committed by that person. And it does not put you in bad light. It's a misconception to think that because you are defending somebody, then that means your interest is to ensure that he goes scot-free. Your interest is that you defend him according to the facts that he has given you. We know the causes of delay in the courts, and we have attributed the causes of delay and to poor investigation, poor pretrial management of cases, and poor articulation of the evidence in court. Now, you will not expect an accused person to come to court and simply surrender his neck and ask to be convicted. Of course, even the interest of the state at times, when it tries individuals, is suspect, because there are political motivations behind it. At times they don't even want to go on with the case. They are content with running the person as if he's guilty in the social media and saying that and going to court, find one reason or the other that they will not go on. The last presidential committee on anti-corruption, I told them that I have never seen any one of them in court in any of the high-profile cases. So on what moral platform do they get up to say the senior lawyers are delaying cases, when I have never seen any of them in court before? And they couldn't give any reasonable answer as to why they were not, because they don't know. So the long and short of it is that those who come from the side of the defense are entitled as Nigerians to be on the committee. It's not anybody's father's birthright. We are entitled as of right because we know the reasons why there are delays in the system. And I can tell you, apart from what I have laid down, is that we seem to imagine in this country that when an accused person is taken to court today, that the case against him starts. No. In England, in the US, in all these modern democracies that have criminal justice systems, a case does not come to trial until well over a year or a year and a half. There are pre-trial steps that are taken, discoveries, documents are exchanged, issues are trashed out preliminary, and you will now isolate the case to the main issues. It takes at times a year or two. There is also the question of scheduling. Now, mind you, there are cases that have been there for the past 10 years, and it is very immoral for a case to come this year and want to overtake those cases. So you need to schedule them. If people don't know that these things take a long time to deal with, the recipe for the failure of a case is let it come to court today, and you want it to go on today. That case will fail.
With all the back and forth, not much has been heard of the work of the committee, but Nigerians expect that this will change in year 2018. Still to come on the program, we discuss issues of infrastructure and funding of the judiciary. Join us again.